Please, Lordship, I beg to mention item number 7, my lord. Claiming its matter can be taken up after 2 weeks, my lord.
Why? This is a long pending matter.
My lord, Mr. Paul is not available, my lord. Yes.
No objection.
If Mr. Paul is not there, you are there.
My lord.
Your name is also here.
Yes, my lord.
Yes.
You are competent enough to take up these matters. Why?
My lord.
On pre-made with petitioner, seeking accommodation on grounds of personal difficulty. The same not be objected to by the state respondent. Matter is adjourned. List the same after 2 weeks.
Item number 1.
Same status report as last year, no? Report file करिए. Yes, Mr. Sawant.
Yes, Lordship, on the last occasion, my learned.
Have you confirmed
Yes, it's confirmed that no charge sheet has been filed till now.
till date?
Yes, till
Yes,
date.
that's correct. No charging. So then you are entitled to default bail.
Yes, Lordship.
No, absolutely. Leave it. But you have to file a separate application for that.
Lordship, there is a one provision where it says I have raised a judgment where it says the filing of separate that is.
As per the postal certificate issued by the GPO, notice to respondent number 2 and 3 are duly served. And so far the respondent number 1, owner of the vehicle is concerned, it is returned to the sender with the remark that insufficient address. Even before the trial court, Your Lordship, we were not able to serve because they have written only Beltola. Beltola is a mini Haryana and or Punjab, you may say. And with that insufficient address, we were not able to serve notice to the owner even before MACT. So it was published in the newspaper. So instead of delaying the matter, Your Lordship, I would submit that I may be allowed to serve this by substitute service. Substitute service by publication of the paper.
Publication in newspaper, Mr. Jindal, you tell me how many person would read newspaper?
How many?
How many person would read newspaper? Would you think the owner would read the newspaper?
Will read. Nobody will read.
You see, we are talking about substantive justice here.
Yes, Lordship.
Because more, you know very well, I also know, you publish in newspaper, it's gone, nobody reads.
Yes, no, unnoticed, yes.
Then you come to court and say, no, that has been, notice has been affected.
That's true, Your Lordship. That's why I am pointing out, even before the trial court, we have made several efforts, even through the Beltola police station and also through the insurance company, because owner is the insured of the insurance company, and they have also returned back to the court that we are not able to locate the insured. So under that circumstances, Your Lordship, nothing was left out. So if and publication of the paper also will cost to the claimant, who's a widow. From the last 11 years, she is fighting, Your Lordship. So what to do about it? So this is the, Your Lordship, postal receipt which may be kept on the record, and the track record shows that
you filed an affidavit of service.
That's and for on respondent number 1, we have to do something.
No, is the vehicle is insured.
Vehicle is was insured at the relevant time. There is
So the insurance company.
They have received the notice.
So their stand is the.
Their stand is this their stand is this, Your Lordship, that vehicle is insured, but the person died due to his own negligence.
Okay, that is beside the point. As long as they you see, as long as they take the responsibility that the vehicle is insured.
And
even without the owner being present, liability can be fastened on them.
Yes.
That's as far as the facts are concerned, it's a different thing.
Same, Your Lordship. And he was a government servant, everything is proved.
Nobody has appeared on behalf of the respondent.
Yangi was there, of course, in the lower court, I don't know.
You do one thing, let the insurance company appear.
Lordship.
In the meantime, you try to ascertain the correct address of the owner.
Not possible, Your Lordship, because
by whatever means.
And we'll file an formal application bringing on record the DPO certificate as well as with a prayer to allow us to substitute service.
That of course. Where is the communication where it is said that the
insufficient address?
Insufficient address?
Yes, Lordship. In the track record, track consignment, insufficient address. And the address itself indicates that it is insufficient. Driver is from Meghalaya. We tried to ascertain from him also. He says, I don't know where he is. I just worked with him for a few months. He stays in Simit.
Driver is dead.
Driver is alive. Only
But you have
the
not taken steps on the driver.
no, driver has received.
Who has received this?
Respondent number 3.
Somebody, I think,
Nobody appeared.
somebody
in the
has received on his behalf.
receipt. He received.
Name is different. Here is a female has received this.
Maybe some fellow from his house has received it, but it is served. Yeah.
Anyway, you see, if the insurance company would take upon themselves to represent these two, as is usual,
Yes.
under section 170 or something,
170.
that is okay.
Mm.
But if they dispute, then even this service of notice upon respondent 2 might be, might be disputed, because the addressee, the respondent 2 is different name. The one who has received the notice is a different person. Could be his sister, could be his mother, we don't know.
No, address is same,
Address is
and that person, if he does not sign it, somebody else from his home sign.
then
It is
then the question of
in case
of service.
in case it is disputed by
In
anybody.
case that's what I'm saying. In case it is disputed, if not, we'll wait for the insurance company to appear. In the meantime, you file an affidavit of service.
I'll file an application. And the records were called. I think it has not been received. A reminder be sent.
Mr. B.K. Jindal and senior counsel appearing for the appellant along with Ms. General Counsel has submitted that the notice issued upon the respondents 2 and 3 has since been affected, and an affidavit of service may be allowed to be filed in this regard. As far as respondent 1 is concerned, the learned senior counsel has submitted that the notice has returned with the note from the post office indicating insufficient address. It is prayed that alternative substituted service may be allowed to be taken upon the said respondent by way of publication in the newspaper. However, this court at this juncture would direct that the appellant confirm the correct address of the respondent number 1 and reissue notice. None has appeared on behalf of the respondent 2 and 3. This is matter up to 2 weeks.
And the records, Your Lordship.
Records, you see, it'll come in due course. Direction has been made. It's not for you to worry about that. If it comes, it will come.
Right.
Now on, point. It will come.
After 2 weeks?
2 weeks.
Item number 3.
May please, my lord. Well, as per the last order, we have supplied the copy of the SLP, my lords.
No, if I recall, the parties have been.
To obtain instructions, my lord, as to whether there is a
Yes, I
possibility of a
think
settlement.
the
My lord, I will need further time, my lord. I have no instructions at the moment, my lord. I'll need further time. My lord is pleased to refix the matter after 3 weeks, my lord. By then, I'll have my instructions.
I think the initiative would rest mostly on Mr. Sangwa's client.
My lord, in fact, we have actually approached the department on 9 December, my lord,
Already.
by way of letter. We've already intimated the department that we are willing to settle the matter.
Believe me, Mr. Bhattacharjee, you impress upon the government. Similarly,
Yes, my lord.
this matter would it would be a win-win situation
For
if you
both.
go for mediation
My lord.
or settlement.
My lord,
It
I'll have
will
my
not-
instructions.
Believe me, it will not end here. It will not end here. If another round of litigation goes, 10 years goes.
My lord, I think that will be more than that, probably.
Maybe more than
Lord,
that.
in my
By the time you will not be there, I'll not be there. Who will reap the fruits? The main person is already dead.
my lord, the pages needs to be reopened, my lord, from the very beginning. The
see,
book
the-
has to be reread, my lord.
The point is this. I've gone through the papers. You see, because this matter, I've come to the fact end of the case. You see, the respondent or the degree holder, for that matter, does have a case. She has a case.
My lord.
But the only thing is, we are talking only about the proportion. We're talking about the quantum.
Quantum, my lord.
Quantum this court may not agree with that.
My lord,
So I'm giving you that hit. It's up to you.
my lord, the degree
Let-
holder
let-
has been
see,
very diligent.
Try to be fair.
Unscrupulously,
See,
no.
Try to be fair.
But the judgment debtor on the other has been
No, no, they were supposed to come with
very,
instructions.
very careless, my lord, in the entire.
True. Everyone is at fault. The system is at fault.
My lord.
So this court will try to rectify whatever can be salvaged, but it is still open to dispute.
We'll have our instructions.
It's up to
by-
you.
My lords. In fact, we have already approached them, my lord. Now it's up to them to come with proper instructions.
You see, be practical and be realistic. And if both sides agree, I think it'll be better for
My lords.
all concerned.
My lord. My lord, we'll have our instructions in 3 weeks' time.
3 weeks.
3 weeks' time.
No specific order will be given in that regard because I've passed that order.
My lord, will kindly note the presence
you
of
have
the
not
parties.
passed in your lordship.
Of course. Learned counsels appearing for all the parties are present. However, on inquiry made by the court as to the initiative taken by all concerned as far as the process of settlement is concerned, process of mutual settlement is concerned, the Learned Counsel has made a prayer for this court to allow them some more time to pursue such option. Accordingly, on prayer made, this is matter of 3 weeks.
Oh, blood.
Give me a copy of the letter to the government.
Item number 5.
Yes.
May it please your lordship. Your lordship, I'm humbly praying that this matter be kindly taken up after 2 weeks, that my senior is out of station.
You are for respondent?
Respondent number 6, your lordship. School Managing Committee.
Who's for the petitioner?
I'm for the petition, Your Lordship. I have no objections, Your Lordship.
You are for state? On prayer made by the Learned Counsel for the Respondent number 6 and 7, or just 6?
6, Your Lordship, 6.
Who is for 7?
Seven is Shri Francis Dakar, Your Lordship.
No, who's counsel for?
No, no, no.
Who's your senior?
Mr. H.L. Shangrisro, Your Lordship.
But here, indication is that Mr. Sangriso is appearing for 6 and 7.
Then now you are appearing for the respondent number 6, Your Lordship.
We'll confirm this on the next date. You just try to find out.
Okay, obliged, Your Lordship.
Gununtu? Number 6. Seeking accommodation on the ground that the learned senior counsel who is conducting the case is indisposed. The same not be objected to by the petitioner and then GA appearing for the state respondent. GA, I missed. I think more. That is adjourned. This is the same after 2 weeks.
Obliged, Your Lordship. Yes.
Items 5 and 6 are connected.
Same order. Same order.
Obliged, Your Lordship.
Huh?